I definitely needed that. Thank you, Nadia. Um, as I mentioned, this is the small business development program here at Tzedek Legal Services. And today we're going to talk about commercial leases. But first, a little bit on our office. We're designed to help low to moderate income entrepreneurs and small businesses with a series of business-related matters. The way that we do that is through a four-pronged approach, where we facilitate community presentations and workshops such as this. We also host small business legal academies, which are opportunities for people to, receive an outline of a specific legal issue and then have the opportunity to have a one-on-one consult with either a Tzedek attorney or a pro bono attorney. We also publish and provide guides and other resources. And then we also take on clients for direct representation. So as an attorney, I manage a caseload, and the team here at the office does that as well. These are some examples of issues that we address. These include business entity formation, contracts, commercial leases, employment law, COVID and different protections and regulations that have arisen because of COVID, access to COVID relief, intellectual property protection, best practices as it relates to internet privacy and accessing or having people access your website online. We also provide advice and counsel on insurance questions, and can provide some baseline understanding of bankruptcy. In addition to this, we have a wide array of resources and referrals that can inform you as a potential client as to some of these legal matters. Before going further, I wanted to outline what are some eligibility criteria for accessing services from Tzedek, including the direct representation that we offer. We do ask for household income eligibility. We ask questions about your business profits and sales. We do ask that you are a for-profit business in LA County. We do not take on cases for nonprofits or prospective nonprofits. And finally, we provide transactional and not litigation services. We have the capability to provide assistance in different languages, both through in-house staff and through a language line that we use frequently. And we're guaranteed to provide accommodations to clients with disabilities. If you would like to get help, here's our website. It's also in the chat. You're welcome to reach out to me by email. I'll also refer you to our online intake application so that you can be put along through the process. Now, with that being said, we're going to move toward the topic of today's conversation. Before that, I wanted the chance to introduce Christopher Cyber, who's practiced commercial real estate law since 1996, mostly representing tenants. He practiced first at a national law firm, then for the last 23 years as in-house counsel for a restaurant company, a fitness club company, a career education company, and now for ECMC Group, which is a nonprofit focused on helping students succeed. So he's one of our pro bono volunteers who's dedicating his time to both supporting our program and supporting you all who are taking the time out today. So I wanted the chance to thank you all for participating, and thank you, Chris, for taking the time to do this with us today.
Yeah, I'm happy to be here. Thanks for including me.
Absolutely. This is just the title page. These are the two of us. And I do need to go over a quick disclaimer before we get started. This training is just for informational purposes. It shouldn't be considered counselor advice specifically for your situation or for your business questions. There's a lot of different factors that can shape the information that we're sharing today. So as I said, this isn't supposed to be substituted for legal advice. It's just supposed to give you a rough primer or understanding about what to expect when you are seeking out a commercial space or entering into negotiations for a commercial tenancy. We're not creating an attorney-client relationship with any person participating, and nothing that this session is being recorded. It's going to be published online, so don't expect any of these conversations to remain confidential. If you would like to take any of these principles and apply them to your particular set of facts, I invite you to either reach out to us individually or confer with a separate attorney concerning what it might mean for you. Going forward, we're going to break this up into 3 parts. We'll talk broadly about commercial leasing. Then we'll talk specifically about the key terms of a lease. And then finally, we'll close out on a rough outline on what to know about the eviction process and how a tenancy might be terminated. And that's in light of what's been going on recently in LA City and LA County and across the country, really, with the expiration of some COVID-19 protections and some looming evictions around the corner. Part 1 is our commercial leasing overview, and Chris, take it away.
Yeah, so we're going to kind of talk about the basics of how you lease a commercial property here in this first section. So first thing to keep in mind and keep this very clear in your head is the distinction between a commercial and a residential lease. So a commercial lease is anything, retail uses, whether you have a store or a restaurant or an office or a warehouse or a place you're manufacturing stuff. Those are commercial leases. And the important thing to remember is the commercial tenant's rights are almost entirely governed by what's written in the lease. Now that's different from a residential lease, which I'm sure probably all of us have entered into ourselves and our families before, renting an apartment, renting a house. That's for a dwelling. Residential tenants enjoy significant protections under the law, and the law will have a lot of things in it that require the landlord to do certain things like making repairs or providing heat, and then those apply whether or not that's written in the lease. So that's a different thing. So there's a higher degree of protection for residential tenants. So today's presentation is about commercial leases, and please don't make the mistake of confusing what we're talking about here with what applies to a residential lease. It's a different set of law, kind of.
So I want to give you a rough understanding of what the timeline might be and what's important for you to keep in mind when you're entering into this type of this type of negotiation. You really want to have your needs and your bottom line very clear to you so that you don't end up negotiating something that's like vastly outside of your budget. Next, you'll want to consult with a professional, and that might include like a real estate broker, an attorney, and then identify and inspect the space. You might even ask a contractor to inspect and pull records for that space. And then you finally would submit an offer, which might be called a letter of intent to lease the space, and then you'll negotiate and enter into that lease. Now, give me a moment, Chris, because I think that the version that I have pulled up, it's the one that had a little, like the bigger bricks of text. So if you give me 2 seconds, I'll be able to get the more updated PowerPoint for us. Sorry about that hiccup, you all.
No problem. Yeah, while Marco's doing that, I can kind of talk a little bit about how you're looking for a space. A real estate broker can be very, very helpful in helping you identify a space, finding something that matches, getting in contact with the landlord, starting to work out the basic details. That can be very helpful. When it comes time to doing the lease itself, having an attorney help you review it, negotiate it is very, very helpful. It's not essential, but it can be very valuable. An insurance broker is someone also we'll talk about later who can help you navigate what insurance you're going to be required to carry, where to get it, where to get good rates on it, and so forth. So those are kind of professionals who can help you in the process. So the first thing Marco was just talking about is the letter of intent, or sometimes it's called a term sheet. So this is usually a short document, 1, 2, 3 pages, something like that, that sets out just the basic points that the parties have reached kind of a tentative agreement on that will go into the lease. These are usually what the rent is and whether there's an abatement, whether there's a period at the beginning of the lease when you don't have to pay rent yet, how long the term of the lease is, which space it is you're going to be leasing, what's the condition of the space, is it as is, or are they going to fix it up for you, or are they going to give you some money to fix it up? We're going to talk about that later. Tenant improvement allowance, that's what it's called when the landlord gives you money to help you build the space at the beginning of the term. Whether you have an option to renew, whether you have a security deposit, maybe whether you have to pay the first month's rent ahead of time, some things like that. So the letter of intent is usually non-binding, even if it's signed by the parties. You should make sure that it says that at the beginning that this is non-binding. You don't want to accidentally commit yourself to something if you haven't been meaning to commit to it. But the other thing to remember is that because it's not binding, it's also not binding on the landlord. So you may think, hey, we've got a deal now and we're all good. But until the lease is signed, either party could still walk away. And if the landlord finds someone better come along or their situation changes, just realize that you're not locked in. You're just kind of, you have kind of just the terms set out. Another thing I would mention is that it's often more successful for a tenant as a matter of strategy to get key items they want addressed into the letter of intent rather than bring them up for the first time when you're looking at the lease document. If there's some certain things you need, like you want to have the top sign on the shopping center pole sign out front, or if you expect the landlord to give you a new plumbing system in your space, or so if there's particular things like that, and you can get them into this part of the negotiation, you're often going to be more successful getting them than if you bring it up once lawyers are looking at the document. Because if it's in here, the lease comes along, you say, hey, look, we agreed in the term sheet that you were going to do this, then usually the landlord will go along with it then. So that's just a kind of a strategy tip for using the term sheet to your advantage in the process.
Next, I want to talk about the type of business entity and what impacts that's going to have on you while you negotiate the lease and during the life of the lease. So when I say business entity, I'm referring to, are you a sole proprietorship, or are you formally formed into an LLC or into a stock corporation? The reason that that's important is because that's really going to determine any potential liability as the lease winds down or as the tenancy winds down. And in the off chance that you do end up having to terminate prior than you had expected, it can have a really deep impact on your exit strategy. For example, in a type of sole proprietorship or a partnership where there's a general partner, then your personal assets are on the line if you choose to terminate the tenancy earlier. Whereas on the other hand, if you had entered the tenancy as your formal business entity, as an LLC that limits your liability, then only the business's assets are really on the line. So knowing which party is signatory to the lease can really impact your exit strategy, because it's going to let you know how much you're really putting on the line when you're deciding that it might be better for you to vacate and close out early.
The type of business entity also, I mean, well, like Marco was saying, it matters under the lease in terms of what assets the landlord could go after if you had a default or a dispute, but it also matters for you in terms of operating the business. If somebody sues your business, somebody comes in and claims they were injured or something, whether they are going to be able to sue you personally versus the LLC, which is the entity which operates that business. So that's also a consideration in addition to the real estate lease part of
it. Thank you for that, Chris. And just on this last point, the question of the creditworthiness of a tenant, that goes hand in hand with something that we're going to talk about later, which is the personal guarantee. And depending on your creditworthiness, the landlord might ask for more or less upfront, right? So let's say that you want to enter into a tenancy just as your business entity, and you don't want to have a personal guarantee attached to the lease agreement, then the landlord might ask for a higher security deposit or more money up front. Whereas on the other hand, if you are backing it up with a personal guarantee, then you have the option of maybe negotiating some of those terms down so that they're more favorable to you.
And keep in mind that a personal guarantee can be structured a lot of ways. The landlord will always want one that's just unlimited, like all your assets. But you can also have a personal guarantee that says, I'll give my personal guarantee up to $100,000. Or you may say, I give a personal guarantee, but if I'm not in default after year one, then it drops down by an amount, and then year two, it drops another amount or something. So you can be creative in terms of how much exposure you're willing to give them to get them comfortable with leasing to you. Doesn't have to be all or nothing.
Next, we're going to identify a couple key terms and then dive deeper into some of those.
Yeah, so now we're talking about the lease itself here. And as I said earlier, all of your rights are what's kind of set forth in the piece of paper you sign, the lease contract. So it's important to understand all of it. And don't be under the mistaken impression that these things we talk about today, these typical provisions, are the only things that could be in there. You really have to be careful and read through the whole lease to understand what your rights and obligations are. There might be things in there that you didn't expect would be in there, and there may be things you assumed are in there that aren't. And the only way you're really going to know is by reading the whole thing or having an attorney help you with that. Now, having said that, we're going to try to cover the most common and important topics you see in commercial leases here. But like I said, understand that whatever's in there is in there. So you got to get familiar with it.
So these are some of those. I'm just going to run through them really quickly. And like I mentioned, we'll go into more detail. We're going to talk about the term and any options to renew, assignment and subletting, rent and how that's defined. Then the question, which is really broad, about improvements, modifications, repairs. If there's any tenant improvement allowance attached to that. We'll also talk about the security deposit, the personal guarantee, like I mentioned, the notice method and what does a notice mean, and what a landlord might provide you a notice for. The default, and then two other key terms, which are the continuous use covenants. What does that mean? And holdover. So I want to outline these because I want you to have in mind that, as Chris mentioned, what's in the lease is really what's going to determine or govern any type of litigation that might arise out of this. So you have to think about, what are you willing to negotiate? And at what point is a certain term just beyond the pale? And if the landlord isn't willing to negotiate that, then maybe it's important to know at the beginning what's going to lead or cause you to walk away, because ultimately walking away is your biggest leverage when you enter into a conversation about leasing a commercial space. I'm going to start off with the lease term and options. There's different terms that define when the lease actually starts. So I'm going to go over the first three, and they're very important because they can be different. The effective date versus the commencement date versus the rent commencement date. So effective date is outlined in the lease. That's at what point is the lease agreement effective? Usually that's upon signing, right? And very often we might find ourselves, you sign, you pay your first month's rent, you move in, you occupy, and that's often how residential leases work, right? Residential tenancies. But that might not be the case here, because you might be able to sign an agreement on the effective date, but the commencement date, so the date that you occupy, isn't maybe until like another month or another 3 months while the landlord is instituting their build out, or maybe the landlord's giving you some time to institute your build out.
Or maybe they're getting the existing tenant out of there. Sometimes the other tenant's not out yet. You sign the lease, and then you know, once they're out, you get the space.
And then finally, you might even be able to negotiate a different rent commencement date. So the landlord might give you a buffer between the period of time when you physically occupy the premises and when you're required to actually start paying your rent. So it's important to keep in mind that the effective date isn't necessarily when you're required to start paying rent, if you can negotiate that into your lease. And you want to have, it's a good idea to have your renewal options outlined at the outset so that you know kind of what to expect for your business as the economy changes over time. If you can have a set increase, a rent increase set in stone for like the next 3 years, the next 5 years for your tenancy, or renewals for your tenancy, then that's going to put you in a much better place when you start to forecast what your business is going to look like and what it can take on as far as expenses down the line. Under these options, you can negotiate what the rent increase might be, whether it's going to be a percentage, whether it's going to be tied to fair market value, and
It's important also to remember. Oh, I'm sorry. Go ahead. Finish your thought.
These can be really beneficial for you as a tenant because, like I said, it'll lock the landlord into a specific like rent schedule as time goes on, even beyond when the initial term expires. Go ahead, Chris.
Yeah, and I was going to say, like everything, I keep harping on this, but the renewal option is only works in the way it's written in the lease, and it's construed very strictly. So the renewal option may say the date that's 180 days before the lease expires, you have to give a written notice, and that has to satisfy the notice part of it. It may not be that you can just email them or call them and say, yeah, I want to stay in. You may have to send a letter to a certain place and have it arrive by a certain time. So remember, when you have those rights, you miss one of the details of it, you may lose the thing entirely. That could be very big thing for your business. So watch those carefully if you're planning on exercising them.
Next, I want to talk about assignment and subletting. This is important to keep in mind because maybe things just don't work out for your business as you had hoped. And this can be a key part of your exit strategy. Essentially, these operate as different ways to have a new party come in and step into the space and kind of release you from some obligations. The difference between the two of these is that under an assignment, a new party steps into your shoes as the tenant. You're released from liability usually, and the ongoing relationship exists between the landlord and the new tenant. Under a sublet, you remain involved as the original tenant, and the subletter comes in, pays rent to you, and then you pay rent to the landlord. That's usually how these work out. Usually, your lease is going to require the landlord's consent, that the landlord has the right to give their consent to whoever is going to take over as the assignee or as the subletter. And these are all terms that you can negotiate into the lease at the outset, as far as what are some key markers or provisions that the landlord is going to hold themselves to when they're evaluating a prospective subletter or a prospective assignee. Something to keep in mind is that a landlord might include what's called a recapture right inside of the assignment and subletting term, where the moment that you ask them for their consent for a potential assignee or subletter, they actually have the right to terminate your tenancy and take back the property. So you just want to be aware of that if that's already in your lease agreement.
One other thing to watch out for at assignment and subletting is somewhere else in the lease will be what's called your use clause. It will say what you're allowed to do within the space you're renting. And the more specific that is, then the harder it is to assign and sublet. Because if your lease says your use is restaurant, and you're operating a Peruvian restaurant, and then you decide you're going to get out of the business and a fried chicken place wants to come in there, then that's still a restaurant and you're covered. But if your lease says you have only the right to operate a Peruvian restaurant, now whatever the assignment and subletting says, the fried chicken restaurant can't come in there unless the landlord agrees to change that, and they may have a sole discretion to say, only the uses that are allowed. So think about, your use may be what you think it's going to be at first, but try to get it as broad as you can so that if you need to change the way your business operates, or if you need to assign or sublet the thing later, that you have some greater flexibility there. Okay, so we're going to talk about rent. And again, in a residential lease, rent is usually very simple. You pay this much per month, and that's kind of it. And that's pretty simple. And a commercial lease can be that way, but often they are a lot more complicated than that. So you have different kinds of rent concepts. The first one is fixed rent, or sometimes it's called base rent. That's typically what we're talking about, the monthly amount that's due beginning of the month. It's usually just stated as a monthly amount, or maybe $1 per square foot per month. As we talked about earlier, you may be able to negotiate for an abatement of fixed rent. Maybe you get a few months at the beginning of the term after you've been able to occupy, so you have time to build the space out, hire your employees, train them, get up and running, so you're making some money that you can use to pay rent with. Of course, when you get concessions like that, they will be reflected in a higher rent rate later or longer term or something. The landlord's going to, expect something in return. Often the first month's base rent is due on execution of the lease. So like Marco was saying, those dates can be different. Like say, for example, you sign a lease today to open your restaurant, and you're going to get the space on July 1st from the landlord after they've done some things to it. And then they're going to give you 3 months of free rent at the beginning. So your rent commencement date is now August, September, October 1st. So those are different dates, and that is all is negotiated in the end of the lease. Now, then, in addition to base rent or fixed rent, you have what's called a net lease. So a net lease means that the landlord has the ability to take the expenses they have operating the place and pass those through to the tenant. So that typically you see this NNN, that means triple net. People will call it triple net. Triple net is 3 categories of expenses the landlord will pass through. Their operating expenses, taxes, and insurance. So operating expenses are things like maintaining the landscaping, repairing the parking lot, maintaining the common areas like the lobby or whatever other things there are, the sign structures. They take the cost of doing those things and they divide it up and pass it through to the tenants if they're a net lease. Same thing with property taxes. They take the property tax bill, what they're paying for the property, they divide it up to the tenants based on their square footage use of the space and pass that through to them. Same thing with their liability. They're going to carry property insurance. With their insurance, they're going to carry property insurance, probably general liability insurance, maybe other things. They're going to divide that up and pass it through to the tenant. Utilities for the common area, they're going to do that as well. That's part of the operating expenses. Your utilities, you'll pay yourself usually, your electricity and water and so forth that you consume within your space. So it's important to understand, though, the provisions for those in the lease are long and complicated and kind of frustrating to get through, but it's really important to understand what the landlord can pass through, what they can't, how it works. It's fairly common for commercial tenants who are new to it to get in, think they're going to be paying one thing, and then discover that, like, wow, the landlord just replaced the whole heating system and repaved the parking lot, and now suddenly I got this bill for a bunch of money. So you need to understand that. To the question that just came up, yes, you should have the right to get an accounting of what stuff they're passing through, but it can be a surprise. It's good to get them to give you an estimate of what it is, and it's good to find out what's excluded. Like, you don't want in the last month of your term the landlord to do a bunch of repair work and you have to pay for it. You should only have to pay for the little part that pertains to the rest of the time you're in there. There's a lot of stuff in there. It's a complicated thing, but it's something to keep an eye on, and it can really affect your bottom line quite a bit. Percentage rent, I'll say quickly because that's not very common, but percentage rent is where the landlord, in addition to these other categories of rent, may have a provision in there saying that they're entitled to a portion of the profits you make in the space. So maybe it'll say that, for example, all the gross sales you make in the space above $500,000 for the year, you have to pay 3% of the part above that to the landlord. And then that can be complicated in terms of having to document to the landlord what your expenses are, what your revenues are, whether they're from this store or another store, and document that and pay the amount. So you have to look at that very carefully if you're going to go down that road. And the last thing I'll say is, Marco mentioned earlier with extension options, they may say that it's going to be fair market rent, which sounds nice. That means the idea is that kind of what is the right amount of rent to pay for that kind of space at that time, in the future when it kicks in. But as you can imagine, that can be a concept that can be decided a lot of ways. It could just be what the landlord says it is, or it could be the two of you engage an experienced real estate person to say what it is, or you both submit bids to that person. There's different ways to look at it, but you have to understand that again, it's going to be what the lease says it is. So the process that it says for what determines your fair market rent, you have to understand that and make sure you're comfortable with it in the lease document.
Next, we're going to talk a little bit about improvements, modifications, and repairs. Important to keep in mind that distinct from a residential tenancy, there's no implied duty to repair for the landlord in a commercial tenancy. So typically the way this works out is the tenant is responsible to repairs to the interior of the building, whereas the landlord is responsible for maintaining the envelope of the building, which includes, the foundation, the roof, any building systems in the lobby and common areas. A tenant might consider requesting rent abatements or termination rights in circumstances where the landlord fails to maintain the premises for an extended period of time. So again, make sure that that's something or identify where that might be in your lease and try to negotiate that in if that's something that you would like.
Before we move to the next one, there's a question regarding the previous, I think it's the previous slide. One, it says, can you ask for proof of those expenses? I think they were talking about the previous slide.
Yeah,
Takashi,
I think I mentioned that. Yeah, you
Yeah.
should be able to get when the landlord passes through expenses, they should have to give you an accounting that shows what they spent and what your percentage is and how it breaks down. Again, how detailed they have to be, what rights you have to object to it or to go and audit their books. That's whatever the lease says it is. So that's
so
all
again,
part of
it's
that
something
consultative.
audit rights are something that you want to negotiate and maybe have up front in your letter of intent as far as what the estimate is going to be for some of those pass-through expenses, if possible, and what audit rights the tenant has, if any, as it relates to some of those pass-through expenses.
Yeah. And the question about the building systems, plumbing and electrical that lead into the unit. I mean, again, it's what the lease says it is, but the most typical thing is that the landlord will maintain things like electrical lines and plumbing to the point that they come into your space usually. And then the part that's in the interior of your space is often the tenant's responsibility. So like if plumbing comes up to the end of the wall of your space, that's the landlord's responsibility. From there to the place you operate a sink or a toilet or whatever in your space, that may be your responsibility. But again, that's the stuff you have to look at in the lease to see who's responsible for doing what.
Because what we're outlining is what's common or typical in some of these lease agreements, but at the end of the day, it really depends on what's written into your agreement. This is you, Chris.
Okay, I think this is if you don't mind, Marco, can you skip to the next slide? Then we'll come back to this.
Sure.
I just think conceptually that makes more sense. So this what we're going to be talking about here is the build out of the space, and you have you can take a space in its as is condition. That means that the landlord just gives you the space the way it is on the day you sign the lease, or maybe as it is, except they remove whatever personal property or other junk may be in there, and that's it. But then you can have what we call tenants work, where the tenant can build out the space to be the space that they want to operate. The tenant will pay for that, but they may be able to negotiate a tenant improvement allowance where the landlord essentially fronts them some money to help them cover the cost of getting up and running and building the space out. That will usually be reflected in the rent down the road. It's for the landlord to recover those amounts they give to you. Remember, you might want to get a later rent commencement date that corresponds to after you've gotten all this work done, so that you're not paying rent until you're in there and operating and making some money. The landlord could also do all or part of the work. You can have the lease spell out that the landlord is going to do these items of construction, put in these items of finish, whatever, and then usually the landlord will pay for that, but it'll be reflected in your rent rate later. Or it can be a combination of the two. The landlord does certain stuff, then the tenant comes in and does other certain stuff. So it's all kind of as it says in the lease. If you're having the landlord do the work, it's really important to spell out in detail what it is, so that you know what you're getting. And it's also important to have the timing of that. I mean, the landlord is usually incentivized to give you the space, work quickly, because they want you to get in there and start operating and paying rent, but that only is the case if you make sure that the rent commencement date is related to the delivery of the landlord's work. So in my example earlier, if you're leasing it now and the landlord's going to do some work so that you can get in there and get open in say July 1st, but say the landlord takes several months longer than we all thought they were going to take to get the work done. You don't want to have your rent start on July 1st while you don't have the space yet and the landlord's still dealing with contractors and whatever. You want to make sure that your rent commencement date moves backwards along with the longer period of time the landlord took. That gives them incentive, and it also makes sure you're not stuck paying rent when you're not in the space yet. But you have to make sure the lease says that so that it works that way. Okay. Yeah, and then we'll go back to the previous one.
Yeah.
And this is talking improvements, modifications, alterations. These are the things that happen during the term after those initial things are done. If you're going to remodel, you're going to add some new things in, you're going to put in a new piece of equipment that's built into the space, you'll typically need to ask the landlord for approval. The lease will say that any alterations like that require the landlord's approval, both as to the work you're doing and usually as to the contractor, the subcontractors you're using. You might, if you think it's important to you, you might try to negotiate in the lease that a consent of the landlord is not required if the alteration is small, a very small dollar amount, or if it's just purely cosmetic, like you're just going to put a new carpet and repaint the inside. You may not want to have to go to the landlord for consent to that. And it's important, we're going to talk about this later, but it's important to keep an eye on what the lease says about the alterations you make and what happens to them at the end of the term. If the lease says, any alterations you make during the term, you have to remove and return the space to its original condition at the end of the term, that can actually be very expensive and time consuming, and that can catch people off guard. They often don't realize that the lease said that. So pay attention to what it says in there, both in terms of what lease you sign, and then when you make decisions about what work to do to the space, what that's going to mean on the back end of the lease term. So we could skip to the security deposit. Yeah.
So the first question related to a security deposit, what form is it in? Is it either a cash deposit or a letter of credit? A cash deposit might be 1 to 2 months rent, and it's typically due at execution. And then you might be able to negotiate a reduction in the security deposit during the term. Also know what your landlord can apply the security deposit toward, right? If any rent is overdue, or the landlord has taken on a cost based on something that the tenant was required to do and didn't take on under the lease, such as a repair, the landlord might consider taking that amount out of the security deposit. And then if that does happen, the landlord might require the tenant to restore the security deposit to its original amount. And as you might guess, landlords are usually pretty aggressive as far as returning the security deposit toward the end of the term. So they might end up applying the deposit toward fixing up the space instead of actually returning it. And that's why you want to have a clear idea of what condition the space needs to be in at the moment at which you vacate, so that you know what to expect as far as a security deposit and have strong arguments on your side when it comes to recovering that amount. You definitely want to make sure that you're covering your bases with extensive walkthroughs, photos, videos, outlining the conditions of the space, both at move-in and when you intend on vacating the space, so that you don't have any surprises and you can protect yourself down the line. Moving on, I want to talk about the personal guarantee. Like it's come up a few times already. That essentially means that an individual is guaranteeing putting their own assets on the line for that lease. Think about different strategies that you might have to negotiate that away. I mentioned previously, like increasing the amount of the security deposit or rent or things like that would protect you, especially as it relates to a potential exit strategy. Chris mentioned some different other creative ways to consider a personal guarantee and how it might be structured, as far as how wide your exposure is over time, especially if you're not in default for the first period or for the first year of the lease. And then when you're making that decision about the personal guarantee, I want you to think about your personal versus your business assets. If the entity signing onto the lease agreement as the tenant is actually a formal business entity.
To the question that came up,
Yeah.
typically, no, it's not typical for a security deposit to be non-refundable. It's a deposit, it's supposed to be refundable, but like Marco was saying, landlords can take an aggressive view of the money's in their hands and it's hard to get back. So you have to be careful what the lease says, and you have to realize that landlord may say, hey, you know what, actually that the condition of the place isn't as good as it should have been. I'm going to have to fix up a bunch of stuff, so I'm going to keep your deposit. So that kind of thing, that kind of dispute is pretty common, but no, it is not usually that it actually is supposed to be left to the landlord at the end of the term if you're not in default and you've paid your rent and everything.
I'm going to talk next about the notice method and period, because it can be very important as it relates to ultimately resolving disputes or being on notice of a potential dispute on the horizon. The lease is going to outline what the proper method of notice is, whether it's through first class mail, whether it's through posting a physical notice on the door, or it can just be through email or a phone call. You really want to know what is the required method for communicating things such as a rent increase or termination of the tenancy, or a modification of a material term, or if the landlord expects to be able to enter into the unit to do any number of things. You want to have a very clear idea of how that is communicated between the parties, and that's going to be outlined in the lease. And the reason it's important to keep in mind is that in the residential context, there's a very clear idea of how notices are conveyed and what the minimum period of time is for these types of notices under California law. But that's not the case here. So that's another distinction between the two types of tenancies. I'm just looking at the chat right now. Okay, yep. Now I'm going to talk about defaults and what that means, and whether that and what the opportunity to cure a default might mean. The way this plays out is that it can be. I'm going to lay it out in the context of unpaid rent, right? So the tenant is in default because they haven't paid rent for that month or maybe several months, and the landlord might serve them with a formal notice under the terms of the previous slide, right? So what's required is that the landlord outlines, you are in default and you have this period during which to cure that default. So it can be 3 days, 5 days, 7 days, whatever is outlined in the lease. You have that period of time to come up with that unpaid rent in order to cure the default and prevent the issue from growing into what might even become litigation related to eviction. If it is a monetary default, then you want to be clear about what the landlord's remedies might be, and it could even be, applying your security deposit toward that unpaid amount and then requiring you to restore that security deposit either the next month or over time. Or even, bringing a lawsuit for that amount of money. What you want to keep in mind inside of your lease is that sometimes when you are in default of your rent, you might encounter what's called an accelerated rent clause inside of your agreement, where it says essentially that if you find yourself in default because of unpaid rent, they're now allowed to require you to pay rent for the remainder of the tenancy. So not just the month that you are past due on, but let's say you have 6 months left in your lease, they can also bring a lawsuit for that existing that current month, and also the remaining 6 months of your lease term. So you want to negotiate that type of term out. You also want to negotiate out consequential damages, because that can just take one initial breach and things will just start piling onto one another. So in the moment you find yourself having the money in hand, you might realize that it's ballooned into an amount that you had not expected or did not realize was right around the corner.
I'd say, in looking at a lease form, assuming the lease had the correct, space and the rent and so forth, almost the number one thing a tenant would want to negotiate and make sure that they're like, if you only got to get one thing in the lease form, probably the one thing you would want is to have a cure right for defaults. So the lease may just say the rent's due in the beginning of the month. If you don't pay, you're in default. And if that's what it says, that's what it is. But you know, a fair lease and one that you'll want will say, if you don't pay rent when it's due, the landlord gives you a notice and gives you 10 days or 5 days or something to cure it before you're in default. Because, you know, you might have just, you know, the check might have gotten lost in the mail. Maybe you just forgot, someone just forgot to send it out that month, or, you know, or something happened. You want at least that chance, if it's just kind of an inadvertent error, not to be in default, not to potentially risk losing your lease, having these big consequences Marco was talking about because of one little thing like that. Now, you know, a decent landlord wouldn't do that to you, but they'd have the right to, and maybe, you know, maybe they got a better tenant they're itching to put in there in place of you anyway or something. And you know, you give them the opportunity by making a default under the rent. So having a cure period, usually there are two different ones, a cure period for rent, usually shorter, 5 or 10 days. A cure period for any other obligations you have is usually 30 days. Like if they say, hey, you were supposed to repair the door to the entrance and you haven't done it, here's a notice, and gives you 30 days to get it done before you're in default to the lease. So that's almost the biggest thing to get, I would say.
Now we're getting close to the end of this section, so I'm gonna push through these.
Yeah, I'll try to go through this quickly. A continuous operation covenant is something requiring you to stay open for all the time or whatever amount stated in there. That's typical in like a shopping mall or something where they don't want to have empty spaces that are closed. They want to have a bunch of things open so people will come there. And if you do have something like that in your lease, first of all, consider whether there should be that at all. But then secondly, if there is, make sure you get exceptions for, you know, closing down to do inventory, redecorating, you know, seasonal stuff you might do, whatever, so that you're not going to accidentally be in default to the lease because you closed down for something you thought was innocuous.
Thanks for that.
Holdover and surrender. These are the terms used. Holdover is the term used for if you stay in the space after your lease term has expired. So if you don't get out when you're supposed to, there will usually be a provision in there saying that, well, first of all, they can evict you. You're not actually have the right to be there usually after the lease term ends. But if they don't, you're going to pay rent at a higher rate. It'll often say 150%, 175%, 200%. So if you end up staying a few extra months, it'll say that you have to pay a lot more for that. As far as surrender of the space, consider what stuff the lease will say, what you are required to remove, what you're allowed to remove, whatever from the space at the end of the term. That can be costly, it can be time consuming. Make sure you understand that. And if you leave things behind, usually the landlord can dispose of them and charge you the cost for that. So anyway, just and I think Marcus said this earlier, it's good practice to take photos and video of the condition of the space right before you hand it off, so they can't come back later and say, hey, there was this big dent in the wall, and maybe that happened 2 days after you gave up the space, but you have no way to prove that anymore. So, you know, it's good to document that so you have some protection against a landlord who may be aggressive about the condition at the end of the space, at the end of the term.
And a final note on insurance, the lease will at minimum require coverage for casualty insurance, so property damage and liability, so it's damage to persons or the property of others. Ask your insurance agent to review the insurance provisions in your lease and to regularly review the policy so that you are in compliance. Make sure that you have a certificate of insurance as proof of current coverage, and do not allow your coverage to lapse. And the lease might require that there are additional insureds and that they are covered under the policy. That'll probably be the landlord and its lender. And like with repairs, there's usually a split of insurance obligations where the tenant may insure the interior of the premises and its fixtures and the property, while the landlord carries insurance on the building structure and on the common areas, things like parking lots, sidewalks, landscaping, and a shared lobby. And if the landlord does carry insurance, just expect that to be passed through to you as additional rent, as one of the pass-through expenses. Now, moving on to the third part of our presentation, I wanted to talk about eviction, termination, and the unlawful detainer. And distinct from residential tenancies, the unlawful detainer process is largely governed by the lease. And just very quickly, unlawful detainer is the legal term for eviction, for the legal case to remove somebody from, to remove a tenant from the property. It's going to be mainly covered by the terms of the commercial lease. And I'm going to outline very broadly what the procedure is. And it starts with a notice of termination, and it goes all the way to a writ of possession. So that means that just because you've received a letter from your landlord saying you need to be out of there by a certain date, it doesn't mean that by that date, the sheriffs are actually going to show up and remove your belongings. It's actually a lengthy process, and there's several legal hurdles that that the moving party needs to go through in order to actually get to that point, which is the writ of possession, which does give a marshal, so usually the local sheriff, the right or the authority to actually remove your belongings and change the locks, etc. It starts with a notice of termination, and that can be for a period as determined by the lease, right? So I mentioned before, it's the notice of default, right? So essentially says like, if I'm terminating your tenancy, if you might have the chance to cure it. So if it's not cured by 30 days, then I'm going to assume my right to actually bring a lawsuit because the tenancy has been terminated. Or it could just be instant. It could be like, you know, the tenancy has been terminated in 3 days. I have the right to actually move forward on the unlawful detainer. For terminations related to non-payment, it's important to keep in mind that under a commercial tenancy, the landlord isn't required to actually put the exact amount of money that you owe, but rather they're allowed to make like a good faith estimate of the unpaid rent, as long as it's within a 20% buffer, either higher or lower, of what the actual amount is. After that period has expired, then a landlord will bring the actual file the actual complaint for possession of the property. It's called the unlawful detainer. They file their complaint, they receive a summons, and they're required to serve the unlawful detainer summons and complaint on the tenant, and then provide proof of that personal service to the court to make sure that they're checking all the boxes and following all the right procedural rules. After receiving service, the tenant has 5 court days to file their answer, and it could be the answer and the request for a jury trial, which is your right under California law. And I just want you to keep in mind that this paperwork, you're not starting from square one. There's what are called judicial counsel forms available online that are available to everyone. And there's the judicial counsel complaint, there's the judicial counsel answer. So if you are ultimately served with the summons and complaint, don't feel like you need to rewrite a whole new pleading in order to get your answer filed. You can just go on the LA Court website or the California Judicial Council website and pull that answer to start working on, pull that document to start working on your answer. It's important to give yourself, to file the answer so that you're giving yourself enough time to maybe negotiate a lease extension, a way for you to stay with your landlord, or for you to negotiate like a facilitated move out where you're able to get out before the case grows bigger and you don't end up with a unlawful detainer on your record. And that can be under the terms of a settlement agreement that you negotiate with your landlord during that process. So even if you don't have any like strong defensible answers, it's really important to get your answer on file so that you're giving yourself enough time and you're not surrendering any rights while you try to negotiate something with them. Once you've filed your answer, you move on to a phase of what's called discovery, which is before trial. During the discovery period, each side has the ability to ask the other to produce certain documents, answer certain questions, or admit certain statements that would then be admissible at trial. So if you don't have it already, that'll be the opportunity to request your rent ledger or copies of all correspondence leading up to that. The landlord's going to also be able to ask for like proof of payment if you have those, if payment or non-payment is at issue. Once that expires, you'll move on to trial, and that's brought by the landlord. The landlord actually needs to file a request with the court asking for a trial date. And at trial, the landlord has the burden of proving in what ways, the tenant might have breached the lease, or if the landlord, followed all the right steps necessary to actually terminate the lease and provide the tenant with notice if the lease had been terminated. And then the tenant gets to rely on the defenses that were outlined in their answer. And I don't have the judicial council form here, but if you do familiarize yourself with it, it does include like a series of form defenses, or like typical answers to some of these complaints, and you'll actually be able to put on and outline the proof that you have for those defenses, should that be the choice that you intend to pursue as far as defending your case. And it's important to know that just because the trial ends, that doesn't mean that that's the end of the unlawful detainer process. After trial, then the prevailing party receives the judgment in their favor. If the tenant prevails, well, then essentially things go back to how they were before the notice was served, and the landlord is allowed to serve the tenant with like another notice of termination after this judgment. It could be based on something else, or because you're a holdover tenant, something along those lines. Keep in mind whether your commercial lease includes a provision for attorney's fees, because the prevailing party will be entitled for attorney's fees under the lease. And then you move on to the phase of what's called enforcement of judgment, where the landlord actually does need to take the steps to enforce the judgment that they received, including a judgment a judgment that's actually for the property itself, right? So in order to enforce that part of the judgment, they need to request what's called a writ of possession, and then take that writ of possession over to the local marshal's office, as I said, in LA County, that operates under the sheriff's jurisdiction. And then they'll actually be able to enforce the writ of possession by changing locks, removing personal property, things like that. But you really don't want to get to this stage. This is very far into the process, and this can have like a very lasting impact, both on your ability to rent a space in the future, whether residential or commercial. It can have negative consequences on your credit and your creditworthiness. So you really want to try to negotiate this at the outset and prevent it from even getting this far.
I'm glad Marco took that part. That's some complicated stuff. Hopefully, yeah, stay out of that world. But it's good to know. Okay, last crack at talking to you, I wanted to just give you two big picture things to remember in the course of this whole universe of commercial leasing. So, we talked this whole thing from the point of view of the tenant, which is what you would be, but it's helpful, I think, to consider the landlord's perspective on this too. I mean, landlords are sometimes aggressive or difficult, and they could be that way, but most of them are business people, just like you are. Their business is owning and operating rental properties, and they expect to get the rent and the other things a tenant's supposed to do so that they can make their loan payments, they can pay their employees, they can make a living. So you may be tempted to think like you're struggling and you can't make your payments, and why isn't the landlord being cool about that? But you have to consider it from their point of view too. They have financial pressures and obligations of their own, the same way you do in your business. So sometimes it's good to think of it as a two-way street like that. The other thing I wanted to suggest is that it's really important to get the lease to protect you in the ways we've talked about, but it's just as important who the landlord is. Some landlords have a track record of treating tenants well, being flexible with them when they have situations arise, and trying to partner with them to make sure everybody is successful. But there are other landlords that have a track record of being very inflexible and aggressive and unwilling to accommodate you, and quick to evict someone and sue them if there's the first thing that goes wrong. And so it's good to find out from your from your broker, talk to other tenants of the center, talk to the people, tenants who used to be under this landlord. Try to realize who you're getting into business with, because if it's someone who's a real snake and is going to try to get you all the time, that may not mean absolutely you shouldn't do it, but then you got to be really, really careful about everything that you do and what the lease says. But you may be also, trying to find someone that's got a better track record, that's going to work with you better and stuff. So just put a lot of effort into figuring that out too.
So just to wrap this up, we don't have too much time for questions. I'd say like another maybe 5 to 7 minutes, but I wanted to leave these resources up. so that you know how to access us in case you had any questions regarding your individual situation. But I'll leave the chat open and keep monitoring it in case any other questions come in the next few minutes.
Or feel free to unmute and just ask us if you want.
Hi, my name is Takasha. I have a question for you guys.
Hi, Takasha.
Hi. So I was looking at a property with a relative of mine who was looking to rent the property, and the building itself had a dysfunctional air conditioning unit. They didn't want to replace, although they had it before, because they explained they had been ripped off by a contractor, whatever. So they required that if she were to rent it and she wanted it, she would have to install the air conditioning unit. However, if she were to leave at the end of her lease, because it is then a fixture, she wouldn't be able to take it. In that situation, she just walked away from it. But could that have been a negotiable point where, okay, if I leave after a year of the contract, I want a certain amount of money back for the air conditioning, or would that not be something a tenant should do?
That's certainly.
Let me take the first stab at this,
Yeah.
Chris.
Yeah,
Sorry
please.
about that.
Go ahead.
So just taking like the broad set of facts that you outlined and maybe suggesting some ways to approach it. So definitely not providing you or your family member with legal advice as to
Right, of course.
Yeah.
Of course.
So and Chris, feel free to jump in, but I think that trade fixtures end up being something that that usually ends up with the property under the terms of most leases that I've seen. But
Yeah.
but Chris, how would you treat that?
Yeah, I mean, that is not a typical thing. However, like we talked about, it's all negotiable in the lease. If you could, get an accommodation where they give you something back for it, or lower your rent in a way that makes it worth making that
Equitable.
investment, things like that.
Yeah.
I mean, it's all, it all interplays with each other. So if you could, if you could find a way to make it work. The other thing I would be careful about is if it's a single tenant space and you're putting in an air conditioner that's just going to support you, that's something you could consider. If it's the air conditioning that it affects other tenants, or it's located on the roof of someone else's space or something like that, then
Right.
I would steer very clear of that, because you don't want to be
Okay.
responsible for stuff that affects other people, or other tenants besides yourself. But if it's like a one tenant thing, and that wouldn't be typical, but sure, yeah, you could agree to do that. I mean, if it made sense in terms of the other things, the rent and the
Excuse
term and
me.
everything else. Yeah.
Thank you.
Mhm.
Appreciate it.
Yeah. It seems like you have the right framework for thinking about it there, most importantly, so that's good.
Using that question as an opportunity to bring up another point that we had talked about, but let's say that like having an operating AC unit or operating HVAC is fundamental to the use of the space. That can bring us back to like the build out period and the commencement period, right? At what point is the tenant going to take possession? Is it required for the landlord to actually make those repairs or installations before the tenant occupies? Or maybe the tenant does agree to make those installations, but they don't have to start paying rent until after they've been installed. So another example of how all of these dates and improvements and build out kind of interplay with one another.
Great. Does anyone else have anything else?
Anything you wanted to add, Chris? Do you think we might have missed or wanted to go into more depth?
Well, thank you all for joining us. Glad you were able to spend some time together and talk about some things and learn some things. So wish you all the best. And as you see on the screen, there's great resources for help as you have particular matters of your own, need assistance, and you're able to qualify for the assistance here or with other organizations. So best wishes to everybody.
And thank you so much, Chris, for taking the time to do this with us. And thank you to everyone who joined.
Yeah, thank you, Nadia and Marco, for all the great stuff you guys do at Tzedek. It's a wonderful thing for the community.
Thanks, you guys. I appreciate it.
Okay,
Thank you.
Thank
Bye,
you.
everyone.
Bye-bye.